Hey, what's up, fellow inquirers? So the other day I came out with a video explaining why I had changed my position on how to interpret Georgia citizens arrest law. If you haven't already seen that video, you can check the card up above, or you can check in the description. I'll leave a link down there. Well, somebody raised a fair criticism saying that I didn't cite a legal expert as to why I had changed my position. Well, I had simply compared how I was interpreting this law with how I've interpreted other types of philosophy and realized that I wasn't being consistent. So in this video, we're going to take a look at how different legal experts come to different interpretations of the law and what those interpretations are. Then we're going to take a look at Georgia's legal experts and see what they have to say about how to interpret the citizens arrest law. So when you walk away from this, you should have a better idea of why there are different interpretations of the law and why different legal experts can come to different conclusions based on the law that they're interpreting. I appreciate you for watching. This is Inspiring Inquiry. Okay, so first I'm going to play you a clip from Colion Noir, who made a video about the Ahmaud Arbery case and his interpretation of citizens arrest law and how one can go about making a justified citizens arrest under Georgia law.
Now let's talk citizens arrest. Under Georgia law, a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. There are 4 elements in this law that must be satisfied to justify citizens arrest. First, a private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. The second element of citizens arrest says a private person may arrest an offender if the offense is a felony. Trespassing in Georgia is a misdemeanor. Burglary is a felony. As I stated before, nothing in the video shows that he committed a trespass or burglary. So the second element isn't met. Keep in mind, you have to meet all of the elements, and we already can't meet 2 of the elements. So there's no point in even discussing the third one, but I will. The third element, the offender is escaping or attempting to escape. Let's say Arbery got spooked by the neighbor who saw him go inside the house and decided to run. If he was committing a felony, then yes, this element would be met because he was leaving the house, and the neighbor would be able to make a citizen's arrest, because if Arbery actually committed a felony and the neighbor saw it or saw Arbery running out of the house with tools or materials, then he could make that citizen's arrest. But as I showed you before, based on the information we have at this moment, there was no felony. At this point, the 4th element is irrelevant, as we've yet to satisfy the first 3.
All right, so as you heard him say, there are 4 different elements in the law that have to be met in order for you to conduct a lawful citizen's arrest. The first being that it is conducted within your immediate knowledge. The second being that it's a felony. The third being that they're fleeing or attempting to flee. And the fourth being the reasonable and probable grounds of suspicion, which he didn't get into because he said it was irrelevant. Well, I disagree with this interpretation, but I'm no legal expert. He actually has a law degree from Texas Southern University, so I would consider him a legal expert. But to me, when interpreting the law, when it states that the offense has to have been committed within your presence or your immediate knowledge, I don't see how reasonable and probable grounds of suspicion can play into that later. If I sit there and witness someone commit a crime, how is it then later that I also need reasonable and probable grounds of suspicion? There is no suspicion. I witnessed them commit the crime. So that's why I don't understand why he's stating that all 4 elements need to be met. But as I will state again, I'm not a legal expert. So let's turn to another legal expert who has a different opinion on how this law should be interpreted.
Let's take a look at the Georgia law on citizens arrest. This is statute 17460, grounds for arrest. What does that statute actually say? A 2-sentence statute. That's all you need to cover. That's all you need to understand. 2 sentences. Here's the first sentence. The first sentence in the statute sets out the generalized grounds for arrest. And this is a citizen's arrest. A private person may arrest. And by generalized, I mean they're not being specific about the nature of the offense in question. It could be a misdemeanor. It could be a felony. It could be any variety of offenses. It doesn't matter. If these conditions are met, that private person can lawfully make an arrest with the same authority as if a law enforcement officer were making that arrest. The second sentence addresses a special case, a special category of citizens arrest situations, and that category is where the arrestor is dealing with a fleeing felon. So misdemeanors don't count. A suspect that's not fleeing doesn't count. It has to be a suspect who is fleeing from a felony. If the suspect is fleeing from the felony, a different legal standard applies than the standard set out here. Here's that second sentence. The second sentence of 17460 is, if the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. No requirement of presence, no requirement of immediate knowledge, but there are additional conditions to this provision, right? The suspected offense has to be a felony, and the offender has to be escaping or attempting to escape.
All right, so now you heard his interpretation of citizens arrest law in Georgia. Now, what he stated was that originally, it doesn't matter whether or not it's a misdemeanor or a felony to conduct a citizen's arrest that happened within your presence or with your immediate knowledge. Whether or not it's a misdemeanor or a felony doesn't come into play until someone is fleeing or attempting to flee, in which case it then has to be a felony for you to pursue them. But I know what you're thinking. That's just confirmation bias. You just went out and found somebody that agreed with you, and now you're touting around them as a credible source for your interpretation of citizens arrest law. So that's when I went to take a deeper look to see if I can uncover something else that would help me interpret this law. And that's when I found this. Okay, so what we have here is a paper written by the Writing Center at Georgetown University Law Center. It was written in 2017. It is a guide to reading, interpreting, and applying statutes. I'm going to go ahead and read the first paragraph. Whether you are working in a law firm, a government agency, or public interest organization, it is likely that you will be required to analyze and interpret statutes. Understanding the tools and techniques of a statutory interpretation will help you to understand the possible implications a statute may have on your client's interests. Although the task of statutory interpretation can be quite nuanced and complicated, this handout will provide you with a few handy tools that will help you discern the meaning of a statute, even when the terms of the statute seem unclear or ambiguous. In particular, this handout will address what to do before you begin interpreting a statute, tools of statutory interpretation, and the theories of statutory interpretation. That can help inform which tools of interpretation you should employ. So the first portion is just going on to tell you what you should do before you even start to try and interpret a particular statute. So these are the three things to start with whenever you're going to try and interpret. 1. Read the statute. The primary language of the statute should always serve as a starting point for any inquiry. Take note that it says at the bottom, keeping in mind that your initial understanding of the text may not be the only plausible interpretation of the statute or even the correct one, which is exactly why we're here. Second, understand your client's goals. So before even attempting to understand a statute, make sure that it's relevant to whatever goal that you have. Third, confirm the statute is still a good law. Make sure that it hasn't been amended or changed or repealed, or portions of it may have been repealed. The second talks about tools of statutory interpretation. This portion goes on to explain what words that you use, how you define those words, and what those words mean in a particular context in a given statute. So just like in the one that we're talking about, there are a few different ways to look at the citizens arrest law, and we can use different techniques to define the words that are used within it. We can use dictionary definitions, we can use common law definitions, commonly used terms, ordinary and reasonable understanding, or plain meaning. So these are all different things that you can take into consideration when trying to interpret a particular law, especially the terms that are being used. So in the law that we're attempting to interpret, it uses a number of these words. This guide gives you a way of interpreting those words and how they're used in the given law. This third one is what I found most helpful in understanding how two legal experts can come to two totally different interpretations of the law. So according to this handbook, there are three different theories that interpreters of law use to understand any given law. Given the range of interpretive tools, which ones should you use? Which tools should you start with? The answers to these questions may depend on your theory of statutory interpretation. To justify your interpretation of a particular statutory provision, you may need to describe which tools of statutory interpretation you use to reach your conclusion. Some readers find certain interpretive tools more persuasive than others. Understanding the various interpretive theories will help you anticipate your reader's reaction to your use of particular tool or statutory interpretation. This part briefly describes the three different theories used in interpreting the law. It's textualism, intentionalism, and pragmatism. We're going to talk about those right now. So textualism, the way of interpreting the law using textualism is you look at the text being used. What are the definitions of the words? How are they fitting within the sentence? How is that sentence fitting within the paragraph? How is that fitting within the law in its entirety? They use this theory of interpretation in an attempt to get a more concrete answer for how to interpret a particular law. Relying heavily upon things like dictionary definitions to interpret the law, they also believe that judges should shy away from focusing too much on what the intent of the law was at the time it was passed. Which leads us into our next one, intentionalism. Now, intentionalists focus more on why the law was created when it was created. What was the context in which it was brought about? What was the time in which it was stated? They use these techniques to get a better idea of why the law was created when it was created so that we can better interpret what its correct understanding is today. So they'll not only focus on the text and the structure of the text, but they'll also focus on what the legislative history was in order to determine what the purpose of the legislator was when it was enacted. Lastly, we have pragmatists. Now, unlike textualists or intentionalists, they don't believe that a statute has one objectively correct meaning. And therefore, they want to take other things into consideration, like its impacts on the public at large. What types of ramifications is this going to have based on how you interpret this particular law? They believe that there are multiple permissible understandings of any given law, and that it's up to the judge at the time of interpretation to decide what is best fitting for this particular case. So now that we've taken a look at this paper, we get a better understanding as to how legal experts can come to different interpretations of the law. There are different words that you can look at, different things that you can reference, and there's actually 3 different schools of theory that deal with how to determine a particular statute. So what we find out is that law is not a set in stone kind of thing, that it is up to interpretation, and we have to leave that interpretation up to the people who are most qualified to do so. Well, given that this is Georgia law, we're going to turn to Georgia's legal experts to see what they feel and how they interpret citizens arrest law in Georgia. All right, so lastly, we're going to turn to GeorgiaLegalAid.org and see what Georgia's legal experts have to say on how to interpret citizens arrest laws. All right, so now in an attempt to avoid any confusion, I'm just going to read their interpretation from start to finish. As a private citizen, you have no authority to arrest anyone with a warrant. Without a warrant, you may arrest anyone who commits a misdemeanor or felony in your presence or with your immediate knowledge. A citizen's arrest occurs when a citizen prevents a suspect from leaving a scene. Citizen's arrest most often happens in cases like shoplifting when the store's manager detains a suspected offender. However, as the following example shows, the manager or employee cannot take such an arrest in every case. In Winn-Dixie Stores Incorporated versus Nichols, a Winn-Dixie customer complained to management that another customer stole her wallet. The court held that the limited rights of merchants to detain or arrest a person reasonably believed to have committed a shoplifting offense do not authorize a merchant to detain or arrest individuals accused by store patrons of committing crimes against other patrons. To make the arrest, an employee would have had to actually see the criminal act committed. Therefore, it ruled that management had no authority to arrest an alleged criminal. The court suggested that the only person who could have made the citizen's arrest was the robbed customer herself. When making a citizen's arrest, a person may not use more force than is reasonable to make an arrest. Deadly force is limited to self-defense or in instances in which such force is necessary to prevent certain felonies. It must be stressed that the right of private citizens to make an arrest is limited. They cannot arrest people for violating local ordinances or regulations because these violations are not technically crimes as defined by state law. Therefore, as a private citizen, you would have no authority to arrest a person who is creating a disturbance by making too much noise. In addition, a private person can only make a citizen's arrest for the purpose of bringing the suspect before a judicial officer. So as we can see right here on GeorgiaLegalAid.org, it claims that you may arrest anyone who commits a misdemeanor or a felony in your presence or with your immediate knowledge. So it doesn't say that to conduct any citizen's arrest that it has to be a felony. It in fact says if it's within your presence or you have immediate knowledge that you may arrest upon a misdemeanor or a felony. So if you take away anything from this video, I hope that you take away that there are multiple interpretations that one can come to when looking and trying to discern a particular law. Different legal experts are going to use different theories and different tools to come to their interpretation of the law. Ultimately, it's going to be up to the lawyers and the judges involved in this case to see whether or not it pans out in a particular way. Well guys, thank you so much for watching my video. Be sure to like and subscribe down below. Share this video if you found it informative whatsoever. And also share your thoughts. Comment down in the comment section below and let us know. Join the discussion. We are talking about things that are pertaining to the Ahmaud Arbery case, coronavirus, anything that you guys want to talk about, different interpretations of philosophy. Make sure to leave it in the comments below. I appreciate you for watching. This is Inspiring Inquiry.